The verdict, finding defendants strictly liable for the dog bite injuries sustained by the infant plaintiffs, is not supported by evidence sufficient to establish that Officer Smith knew or should have known of the dog's vicious propensities. See Patron versus Fernandez, 12 New York 3rd, 546. In the very brief time he spent with the abandoned dog, Smith observed that the dog was friendly, playful, and rambunctious. Further, Smith saw plaintiff petting the dog and did not see the dog growling or lunging at any time. Indeed, plaintiff testified that the dog was playful and friendly both to her and to a family sitting in the precinct house. Even crediting the testimony of plaintiff's husband that he saw the dog growl and lunge and that a longer rope was needed to keep the dog inside his car, that testimony was not supported by the inference that Smith knew or should have known of the dog's vicious propensities. See Phillips versus Coffee to Go, 269, Appellate Division 2nd, 123, 703. The evidence was also insufficient to establish that Officer Smith owned the dog. See Patron Supra. He had taken temporary custody of the dog with the intention to transport him to the ASPCA, and the dog was in his possession for at most a few hours. In any event, he had transferred any right of his to the dog to plaintiff, who had possession of the dog at the time of the attack. Contrary to plaintiff's contention, the evidence showed not that she was holding the dog temporarily for Smith, but that she had the right to keep the dog or give him away. Further, there was no evidence that Smith wanted the dog back or that he retained any control over the dog. Plaintiff has no cause of action in negligence, Patron Supra. In that regard, any violations by defendants of agriculture and markets law is irrelevant. In an action inter alia to recover damages for trespass and nuisance, the plaintiff appeals from an order of the Supreme Court, Nassau County, entered June 23, 2008, which granted the defendant's motion for summary judgment dismissing the complaint on the ground that it was barred by the principles of res judicata. The defendant, Citibank, hereinafter Citibank, leased premises at 925 Hempstead Turnpike, Franklin Square in Nassau County from non-party American Real Estate Holdings Limited Partnership. The defendant, Citigroup Incorporated, hereinafter Citigroup, is the parent corporation of Citigroup. The lease expired on August 31, 2004, and Citibank surrendered the premises. American Real Estate thereafter conveyed the premises to the plaintiff Lighthouse 925 Hempstead LLC, hereinafter Lighthouse. Lighthouse has since conveyed it to another entity. On February 17, 2005, Lighthouse commenced an action against Citibank and Citigroup, alleging, among other things, that they had breached the lease by failing to remove a drive-through ATM before surrendering the premises. The Supreme Court, New York County, granted the defendant's motion to dismiss that complaint on the merits in an order dated November 9, 2005. Lighthouse commenced this action against Citibank and Citigroup on September 12, 2007, alleging, among other things, that the presence of the drive-through ATM on the premises constituted a continuing trespass. The defendants moved for summary judgment dismissing the complaint on the ground that it was barred by the principles of res judicata. In an order entered June 23, 2008, the Supreme Court, Nassau County, granted the defendant's motion. Lighthouse appeals. Res judicata serves to bar future litigation between the same parties or those in privity with the parties of a cause of action arising out of the same transaction or series of transactions as a cause of action that was raised in a prior proceeding. The fact that causes of action may be stated separately or invoked differently under different legal theories will not permit relitigation of claims. Here, both this action and the prior action arise from the same transaction, namely, the defendant's alleged failure to remove a drive-through ATM. The fact that Lighthouse now invokes the legal theory of trespass instead of breach of contract, which it argued in the prior action, will not permit it to relitigate the claim. Therefore, the Supreme Court properly granted the defendant's motion for summary judgment dismissing the complaint on the ground that it was barred by res judicata. It's a short form for res judicata.
What is that?
Res jud.
Res jud? How often do you get res judicata? What does res judicata mean? Let's see. Res judicata means...
It means that the issue that you are litigating has already been decided in another case. So that if the appellate division in a case similar facts has stated so-and-so, that's the law. So you can't come in and say, I'm going to bring an action on the that has nothing to do with that law. I mean, that's the law. So the other side brings an action to dismiss your case on the ground of res judicata that it's been decided here. Smith against Jones, 8 years ago they decided it.
So that's a reason for summary judgment?
Well, it's the judge may not grant it because he may feel that, well, that was a decision that might get overturned. But if it's something that for 100 years has been over and over again, they find the same thing, then he may grant it. You're not going to get this upset. So there's more to it. Res judicata has to have the same parties. It has to be a case that you brought. For instance, you might bring a case in the Supreme Court, you lose. Then you bring a case, the same case, in the federal court. So the guy will say, wait a minute, you tried it already. It's res judicata. You tried twice for the same, just goes to a different court.
That's double jeopardy also, right?
Well, it's not double jeopardy, but the double jeopardy has to do with the criminal case, not civil. But now, the other thing where it's just been decided over and over and forget it, you never get it turned around, is called, there's a legal term for it, I forget. So like parallel ideas, but they're different. Because the res judicata has the same parties.
Res ipsa loquitur?
Huh?
What's res ipsa?
No. Res ipsa loquitur. See, loquitur in Latin means to speak. If you know that, it means the action speaks for itself. You're driving along and then you veer off the road and you run into a house. That's a res ipsa loquitur. That's what they call a res ipsa case. The house isn't supposed to move away. You went into the house, so what's the liability? You know. But you could say that the house is only a foot from the highway. That could be. But if say the house is 30 feet back, then you're drunk or something. You're running over the lawn. You smash into the house. So the guy who owns the house, he sues you for having to repair the house and all the rest of it. So you don't have any defense. What's the defense? So that's a res ipsa case, res ipsa loquitur. Or let's say you have an accident and some guy goes on your side of the road and smashes into you. It's a res ipsa case. Now there are defenses to that. One is called the doctrine of the last clear chance, where let's say you're going along on the highway and you see this guy coming on your lane about 1,000 feet away, but you had a lot of chance to get off the road. You see him coming at you. Instead, you keep going. Boom. You didn't do anything. You had a last clear chance to do something about it. You didn't. That's a defense. So the guy could be on the wrong side of the road and he could still win the case. And another aspect, I had a last clear chance case here in New York City where the subway guy, he's coming into the station, the conductor. He says, I saw this coat on the rail about 1,000 feet away on the other side of the, as I came into the station slowly. I saw him. But I figured, it's only a coat. I kept going. Then about 20 feet before I realized, hey, that's a guy. went in a cart. And he ran him over. He took his leg off. So the guy sued the railroad car. He shouldn't have been on there, but he said, just a minute. The doctrine of last clear chance, he could have stopped. Instead, he made a stupid judgment. It couldn't be. Come on. Stop. If you're wrong, you're wrong. Instead of that, he kept going, and then it was too late when he realized that, it's a body. So I still remember that case. That's a good example of last clear chance. What's he doing on the railroad? You might say, what's he doing on the track? Well, the other side of it is, you didn't have to run him over just because he's on the track. People fall on the track.
Yeah.
So anyway.